Yes, Ms. Bowe.
Thank you, Chair. Commissioners, the engagement before we took the lunch adjournment, most of the answers are covered in aspects of the statement. And so I'm not sure if we should rehash those. Paragraph 47 in particular, you'll see the witness dealt with why he was sending that and even confirms that he wanted that this verification and outstanding investigations ought to have been done before the arrest and not after. At paragraph 48, he explains why the charges of corruption didn't make sense, in particular that to contend that a future corrupt act would be purely speculation, as observed by the commission, would be fortune telling. So all of that was covered in the engagement prior to the break. Paragraph 49 is where he deals with the investigation team's response, and this is where I propose we start so that we can note the response that was given and then take it from there.
Thank you. Advocate Serunye, I'm sure you agree with it, that we skip and go on to paragraph 49. Is that fine?
It is in order, Commissioners. I agree.
Thank you. Thank you. 49 then.
Thanks very much. And from paragraph 49, now after they've responded to my email now, I'm saying a number of the assertions advanced by the investigating team in response to my questions did not appear in the docket. By way of example, the responses referred to Ms. Mokwele's father, said to be a suspended brigadier in the Directorate for Priority Crime Investigation, who had attempted to corrupt investigators, and to a theory concerning the capture of a sensitive intelligence resource. I could find no evidential foundation for these assertions in the docket, and their relevance to the charges was not apparent.
Advocate Serunye, can you just stop there for a second? Commissioners, the response that we're referring to there is at page 29. It's annexure PS4. Again, we'll have to work up from page 30, actually. So you'll see at page 30, the email there is from Advocate Serunye to the team. What follows thereafter is a response by Mr. Peramore, where he attaches his comments in text. You will see the comments if you go to page 31. The blue would be the additions. Is that correct, Advocate Serunye?
Indeed, the blue is the answers.
Yes.
Of Mr. Perumal.
And you testified earlier that for the most of it, what they did was to recite provisions of the legislation and didn't answer substantively to the questions that you had posed.
Correct, Chair and Commissioners.
And the example you were making is at page 36 in the response. And that is in respect of 3.7. Is that correct?
That is correct, Chair and Commissioners. That is where they are saying something about the father of Ms. Mokwele having been a brigadier in the force, but this is not supported by any evidence, and doesn't really take the case any further.
And I noticed that there are no answers to some of the questions.
I agree, Chair. Some of the questions were not answered.
And the remaining that were answered, they indicated that some of those subpoenas would still need to be issued. Is that correct?
That is correct, Chair.
Commissioners, that should deal with the response.
You've got question 3.6, so the answer 3.6 at page 35.
Yes. Advocate Serunye, there you had asked why the generals would have gone out of their way to rig the process. So it seems that there was an explanation covered there in relation to the use or abuse or capture of TSS.
Indeed. But this, in brief, their response to my question was as follows: that Senior Investigator B. Padayashe, Colonels Bapela, Van Vieren, and General Khan will explain what TSS is. It is the most valuable intelligence resource, and accused one, in brackets, who did not need to chair post for a brigadier, as a Major General, could have chaired the panel. Accused one had a desire to ensure full control over TSS, need to know of its operations. He clearly did not have any confidence in any of the vastly skilled and experienced colonels of the crime intelligence, capture of the section TSS. If you read that response, clearly it's not answering the question I was asking about why these generals in the SAPS would go out of their way to rig the appointment process and risk their jobs to flout the National Instruction 11 of 2017 to appoint Ms. Mokwele. Their response talks of the intelligence resource, TSS being, it doesn't really answer the question. It's irrelevant.
Then 3.3, and I just want to understand what you understood there. You've got that question, do we have evidence in the docket to prove allegations of corruption? And then the answer is yes. But I'm more interested to understand what you understood this to mean, which is if you read in that 3.3, that answer, the second line from the bottom, it says they acted in an incomplete, biased, dishonest manner designed to achieve an unjustified result. And then this is the part. Accused one needed to ensure control over TSS. And then in brackets, you have KZN Colonel. And then post withdrawn, re-advertised by accused one. In brackets, you have Khan, it says. And then accused one moved to advertise. Solicits accused 5. There's a Van Vieren again mentioned, and Bapela Van Vieren. What did you understand these names here to mean? And maybe let me be more direct. Where it refers to General Khan, what did you understand that answer to be?
Thanks, Commissioner Baloy. He says there that the initial advertisement, which was placed by General Khan, had been withdrawn, and the post was then re-advertised externally to allow civilians to apply. But that still does not answer my question on what is the evidence in the docket that proves allegation of corruption against any of the accused. And by the way, the withdrawal of that advert, I don't know what relevance the withdrawal has to the advert being done the second time around and being advertised internally and externally to allow civilians to apply, because there is nothing wrong in doing that. We don't know what the results of the first advertisement were, if the SAPS managed, from the people that they managed to interview, they could identify potential suitors to the post. We don't therefore know why they didn't go through to appoint people and then re-advertised. And therefore to want to bring the fact that the first one which was drafted by General Khan, was withdrawn, and I don't know what's the relevance of that, honestly, to the question, what is the evidence of corruption in the docket? And TSS, a kernel in KZN, I don't know who they refer to there, and what the relevance of this is. It's like a person having their own theory to say, this is why they did it. They did it for this particular purpose. Or maybe they had information, other information which is not in the docket and which they are not telling me. But for that, I cannot understand with this one paragraph what message they're trying to portray to me. It appears as they were investigating this case, there's this other information in the background which is not given to me or to the prosecutors, or at least not forming part of the docket. And that is not going to help to prove our case, honestly.
Okay. Lastly, from me on this, at question 6, the answer to your question 6, where you ask, where you say she also made misrepresentations in her CV, fraud in brackets, the investigators should follow up on the validity. And then the answer from Mr. Perumal is section 28 to be authorized urgently. NB concluded on 26 December, and then he goes on to say Boxing Day, and he underlines it. What were you made to understand was the agency here was urgent about this matter? That's the first question. The second question is, did you consider it an urgent matter that needed to be brought to trial very quickly?
Commissioner Baloyi, I don't know what the agency was about. And like I said, my impression after reading all these documents was that the matter was rushed to court, and it was done so when it was not ready to be enrolled. I don't know why it had to be done the way it was done. We talk about these things in the office. We have training, we have a manual that guides us on how to do our work. Like I said earlier, we don't arrest people only to place the matter on the roll and postpone for further investigations, which is what happened here. I don't know exactly what was the motivation for this agency or rushing this case to court.
Thank you. Thanks, Ms. Bell.
Thank you. Then, Advocate Serunye, if we can...
Maybe just to add, I've worked on a number of these matters in the ITEC, and I must say, looking at the history of this case, where the authorization was done in December of 2024, and the arrest is done in June, say 6 to 7 months. This is one of, I've never seen a case being done so quick, where in December authorization and in June, this was done so hastily. If investigations were completed and it was ready, I would have said, well, the investigators did a very good job in this. But they rushed it to court, and clearly it was not ready. I don't know why.
Is your point that there may have been something to the urgency, because normally you wouldn't be able to investigate a complex matter that quickly?
In 6 months, it's
also very clear from the docket that the investigations weren't complete.
In 6 months, it's impossible. I didn't know or suspect anything at the time, but things did not look right. But knowing what I know now, what I've heard in the commission, it clearly shows that there were other things happening in the background, which really led to all of this. I wish I could, at the time, have the ability to see into the future. Then I would not have, involved myself in this. Maybe I would have quit it more. Maybe I would have acted firmer. But unfortunately enough, just a normal human being who don't have those powers. Only seeing things now as they're coming out here.
Maybe another statistic, and to ask you to comment really, is that you may not be aware of, if you are not, is that the investigation in terms of 28-1 was authorized, I think, the 28th or the 30th of May in 2025, and the arrests were in June already. How does that compare with your experience from investigation to now we go to court in terms of timeline?
Thanks, Commissioner Baloyi. Yes, I think I was listening on the news. I've heard that. That can only mean one thing, that as at May, when the 28 was authorized, the investigations were so advanced to a point that one could say it's actually ready for court. That is why when they authorized the investigation in May, then the next month, the arrest follows. I don't know if between the date of the authorization in May and 27 June, if there's any investigations that were done and how many statements were obtained in between that period. I doubt if there's any. It appears the moment they authorized the investigation, for them the case was ready for court. It was just an issue of drafting affidavits for warrant of arrest and doing the consultation between the DPP and the IDEC and to get the matter to court.
Thank you.
Advocate Serunye, you can then move on to paragraph 50. I think you've dealt with the first part of it. What you hadn't dealt with is your request that an HR expert assess all the applications.
Yes. Thanks, Council. I'm at paragraph 50. Now, with all these questions that I'm having, in being new into the matter, I wanted the investigations to be covered. And my affidavit reads, as regards the qualifications relied upon, SAQA confirmed only Ms. Mokwele's matric, diploma and engineering degree. Her project management certificate and her MBA were not verified at the time. Verification was only obtained belatedly after the arrest and after my repeated prompting. In addition, no HR expert had been engaged to assess the full body of some 76 applications so as to determine whether the disqualification of other candidates and Ms. Mokwele's progression to the shortlist and appointment had been proper. Determination of that nature could not be made without such expertise. I raised this in one of the queries that please take all the 76 applications that you received, appoint an HR expert. You are not HR experts. You cannot say this one was favored over this one. This one received more scores compared to, you don't know how the scores were done, why a particular candidate would have been given, especially now the last three candidates. Only an expert, HR expert in that field can be able to do that investigation for you and compile a proper report. And from there on, we know we have, if the HR picks up, if the expert picks up mistakes or favoritism, he will say so. But you as investigators do not have that capability to say this one was favored over that one. You don't know why this got 68, 69% and Van Vuren got 48%.
Advocate Serunye, I think you've dealt with this earlier, but just maybe clarify which qualifications were verified before and which ones were verified belatedly, as you say in paragraph 50.
Yes, thanks, Commissioner. The affidavit we got from SAQA confirmed the matric and the diploma and the, I think it's an engineering degree. Yes. And these two that I had questioned about, these certificates that I questioned about, the project management and the MBA were verified.
They were also verified, but after you became...
After I had asked those questions, yes. On that email of mine, I'm saying, please verify, because I can see that in her CV or the application, she's raising an issue of an MBA and a project management. MBA, one of those, like we dealt with it earlier, she clearly states, I'm still in the process of finalizing this. I think it was only finalized a month after her application was in April and it was finalized in May. But on her CV, she states it.
And the importance of that is that would have been before the interviews, even before the appointment.
That's true,
She would have had the MBA before the October appointment.
That is correct, Commissioner, yes. When she said for interviews already, the MBA was completed.
She had already obtained MBA when she sat for interviews and when she was appointed.
That is correct.
Yes.
Commissioner, yes.
And Advocate Serunye, was an HR expert ever appointed or engaged, as you suggested, to your knowledge?
It was not done, Council. The appointment, or at least efforts to appoint an HR were not followed up, were not made. I'm not sure now as the matter stands now, because I'm no longer part of it, but this was not done.
ordinarily, would you prepare a charge sheet which contains a charge on such an issue, this HR aspect, let's say, even before you consult with an HR expert?
I would not, Commissioner Baloyi, because what I'm going to allege in that charge sheet would be information that is not verified. So at least if I have an affidavit and a report of an expert and I consult with them and I'm satisfied that the expert gives me more information, then I can allege those issues on the charge sheet. But before that, I can't. Otherwise, I'm just speculating and information comes afterwards that, no, there was nothing wrong with what you are alleging, like it happened with some of these things.
Thank you.
If I were to give an example about, say, in a murder case where allegations are that the deceased was shot with a fire, or the deceased was shot with a fire, and people find the body lying there, and they assume the person has been killed by being shot with a firearm. But still, the post-mortem has to be done. Experts have to check, is this wound consistent with an injury that can be caused by a bullet, and then make their report and say, this injury is consistent with a bullet wound. And only then can I, as a prosecutor, with certainty say, this body, the person was killed with a firearm. But otherwise, I can make a mistake. We can assume that the injury was caused by a firearm, only to find that it was a step wound or the person fell on top of a rock, and so on. So these aspects are important in that sense.
Advocate Serunye, at paragraph 51, you deal with your response. I just wanted to note on the 17th of August, you responded twice. The first response is at page 29, PS4 at the top. You'll see there that was your first response.
Indeed, commissioners.
Would you like to put that on record?
That response was after receiving the response to my first trial note, who was asking questions. After receiving the blue note, you see, I'm sort of frustrated by that, and I'm saying to the two juniors, Advocate Tlhatjwayo and Advocate Serunye, that I'm asking questions. Instead of providing me with answers, I'm provided with a citation of PRECA. I know what section 1, 2, 3, and 24 of PRECA say. I do not want to sound critical, but reference to section 24 is misguided and misunderstood. Section 24 would be relevant if the generals were the ones that had received gratification from Mokwele, who was seeking to obtain employment from the public body. The law must be applied to the facts. What I want to know are the facts. It does not help to hide around the fact that the awarding of the position or post to Mokwele was a gratification. The fundamental question is, why are we saying it was a gratification? In brackets, in the context of the case, that is on the facts before us. Why are we saying it's a gratification? It doesn't help me to cite what section 1 of PRECA says, that a gratification includes employment. I know that. Why are you saying, in this case, this appointment of Ms. Mokwele is a gratification? They don't provide me with the evidence.
And this response was just to the two junior prosecutors.
Yes.
You then do a second response, which is at page 52. And that response is then to the whole team.
Yeah.
I don't propose that we go through the entire response. A summary of it is at page 50, at paragraph 51. So then we can take it from there.
Before you do that, did you get a response from your junior prosecutors to the email at page 29, Ms. Ramsame and Ms. Tlhatjwayo?
I did not get any response, Commissioner Baloyi.
Thank you.
Yes. Counsel, on page 52, after sending the email to Advocate Tlhatjwayo and Advocate Ramsame, I then responded to to the email, the blue explanation, you'll see the first person that I'm sending a message to is the one that I would have sent, that I would have received the email from, being Chief Perumal, and the rest of the investigators, but again to the prosecutors. In brief, saying to them, my email and inputs received.
Advocate Serunye, my proposal was
Yeah.
for us to look at your summary that you've done in the statement.
Okay.
So at
It's on
paragraph
page-
51,
Paragraph
page
51, thanks.
15,
Okay,
you'll
yes.
see in short.
Correct. In a nutshell, that email I'm repeating here by page 51 of my affidavit, rather paragraph 51 of my affidavit, where I'm saying, in my reply of 17 August 2025, I set out my analysis of section 4 of PRECA. In short, section 4, subsection 1, paragraph A contemplates a public officer who accepts gratification from another person, and section 4.1b contemplates a person who gives gratification to a public officer. On the state's own allegation, the position was the other way around. It was alleged that the generals, in brackets, who were public officers, gave the gratification in the form of employment to the civilian, Ms. Mokwele, without it being shown that what Ms. Mokwele was thereby to do. That allegation does not fit the wording of section 4. I further explained that the presumption in section 24 did not assist on the available facts, since it would have been available only had Ms. Mokwele been the giver of the gratification to the generals. I concluded that the corruption charge, as it stood, was defective and did not comply with the definitional elements of PRECA, and was liable to be challenged in terms of section 85 of the Criminal Procedure Act. I remained of the view that if corruption were indeed present, its existence depended upon establishing a motive or quid pro quo through further investigation. The bank statements, cell phone records, and computer data of those concerned, and any family or other relationship between them, and that, absent such a motive, a charge of corruption could not properly be sustained. This work had not been done before the arrests were effected. Taken together, the questions I raised remained unanswered on the material in the docket. The significance of this is twofold. First, it demonstrated that the arrest had been premature. As I put it in my correspondence at the time, the matter had been rushed to court when it was not ready. Second, and more fundamentally, the nature of the unanswered questions demonstrated that the preliminary investigation had not been properly conducted. Alternatively, that there was no case. These were not peripheral queries. They went to whether the essential elements of the offense charged could be established at all. I also raised the question as to the basis upon which the matter fell within IDEC's mandate. I record for completeness that I considered a matter of this seriousness involving senior officers in the intelligence environment to be one that could be appropriately be handled within the IDEC space, whatever difficulties attended the matter in which it had in fact been investigated and prosecuted.
I want you to go to PS 11 on page 102.
I'm there, Commissioner.
Are you there, Advocate Serunye?
Yeah.
It's an email that you sent to your colleagues on the 26th of August, 2025. Do you see that?
I see that, Commissioner.
And the very first question you ask after the greetings, but this relates only to the Lushaba matter, as I see, it doesn't relate to both of them. But you ask the main questions, colleagues, does this case fall under the mandate of IDEC?
Indeed, Commissioner.
So this is maybe 2 weeks after you came into possession of the dockets. You were already concerned about IDEC's mandate.
Indeed, Commissioner.
Now, going back to the Mokwele/Khumalo matter, once you discount the corruption which you say, as far as you concerned, based on your understanding of PRECA,
Yes.
it just wasn't there. So if you remove corruption and you leave whatever that remains, would that fall within the mandate of IDEC?
But definitely not, Commissioner Kumalo, because if I discount the corruption, then let's say what I'm left with is fraud, and that would be the fraud against the civilian.
Yeah.
Because in that case, then the generals would have been my witnesses, that is the persons to whom the representations were made. And it's clearly a lower court matter, regional court, maybe district court even. It
And
clearly
you
did not
can't
belong.
have it both ways. You can't say they colluded and then they were defrauded.
Yes. If I'm ending up with a fraud, they are victims. They've been defrauded as well. They've been representation made to them.
Yeah.
Then I cannot charge them with her. But if the investigations which I wanted them to do, where I'm asking questions on your theory, if there's corruption, then there's collusion. If things did not happen this way and happen that way, if the national instructions were breached, then we're talking collusion. If I were to say, but these high-ranking officials in the intelligence unit, could they not pick up, if there was fraud, could they not pick up this fraud? And if I come to the conclusion that they closed their eyes to it, then that means they colluded with her. That is why then the collusion. But that would have been if the evidence points to that. But on your initial question, if I ended up only with fraud, then clearly doesn't belong in the IDEC space. It was not, even the magistrate questioned it on the first appearance. He said, this is not that kind of fraud or corruption that I deal with on a daily basis.
And you would have had to send it to an HR person, as you say. An HR person would have had to assess whether, is this a misrepresentation or is it a simple case of people interpreting a provision differently? The reason why I'm asking you this, maybe we should deal with it now so that we don't come back to it. If you go to file 2, on page 179, I know you had it next to you.
Yes, I did. On page
179.
179. I'm there, Commissioner.
The first bullet that you see on page 179 says, must have a minimum period of 3 years appropriate managerial experience. And this is the important part, in the field of the post. So not just any managerial experience in the field of the post. And then when you go to page 60 of your statement, your annexures on page 60.
Is that paragraph 16?
Paragraph 17.
17.
60, page 60. It is PS6.
Yes, I'm going there.
And then paragraph 17.
I'm looking at 17,
Yes.
Commissioner.
So the definition of appropriate managerial experience, it comes from clause 2 of the National Instruction 11 of 2017.
Sure.
And it defines that as experience at a level higher than the supervisor. That's all it says. It doesn't say you must have been a manager at your job. Because if you were a manager at your job, then you would have to say, at my employment, I was a manager. So if you go back to 178,
Yes.
if an advocate had applied for this position, for example, and it was an advocate who's been practicing for 20 years at the bar, the education qualification would be there, LLB. And then when it comes to this requirement, he would have to tell you, because there are no managers at the bar, I can tell you that. But I would have to then explain to you why my experience is an appropriate experience at a level that justifies appointment. And I assume it's the same if somebody was a prosecutor for 25 years. They may not have been managers at NPA, but because they meet the educational requirements, now what you want to know is, do you have the appropriate managerial experience for the role? Not that you must be a manager at your job. Now, I don't know if you have file 3 with you.
I have it.
On page 908.
I'm on that page.
If you start on 907, what you have is the job description of Ms. Mokwele at BMW.
That is correct.
On 907.
That is correct.
And then it describes the role, maintenance and fastening planner. And then there's the job description, job valuation, PZP3. If you go to 908,
I'm on page 10.
there is then the description of the role. And halfway down the page, you will see that role of the described function, please check where appropriate. Do you see that?
I see that.
And then there's a tick, she's an employee, and then project management and functional leadership. So that is since 2007, that is the role.
Yes.
And then if you go to the next page, 909, it sets out the key responsibilities of this person. It's a lot of them.
Yes.
It's about 60. Now, all of them are leadership in nature because they're about directing, they're about leading, they're about controlling, they're about being responsible, they're about being responsible, they're about being responsible. Do you see all of those?
I see that.
So they are not about, no, somebody will tell you what to do and you will do it. This function requires that she be responsible for all those things.
Yes.
So it was her responsibility to make sure that the people below her, whether they report directly to her or indirectly, make sure that those things happen.
Indeed.
And then one has to interpret whether that qualifies as appropriate management experience. And as you say, an HR person should have done this. But what IDEC people did was they went and obtained a 4 July 2025 affidavit from Mr. Simon at BMW. But the question they asked is the wrong question because their question was, is Ms. Mokwele a manager at BMW? But that's not what the role requires.
Yes.
As you quoted the instruction on page 60 of your, it's appropriate experience at a level above the supervisor. That's all you are required to show.
True.
But those are HR matters that somebody who's steeped in HR is better placed to deal with, including, for example, the public service, the PSC, the Public Service Commission. It's not for IDEC investigators to say you are a manager or you are not a manager.
I fully concur with you, Commissioner Kumalo. That is why I said to them, get an HR expert and take all the 76 applications. Look at them. It's not up to us to say this one qualified, this one not. Yes, there are those that on the face of it, when you look at the application, the person would have been disqualified because they don't have the necessary qualification or the application was received late. Those
And
are
then
straightforward.
it becomes a matter of interpretation if you go back to 909, whether somebody who has done that for, let's say, from 2017 to 2024, that's about 7 years,
Yes.
more or less, yeah.
Yeah.
So you can say, does that then qualify as appropriate managerial experience as defined in the national instruction? So that's how one should deal with it.
I concur, Commissioner.
And quite rightly, you said we are not qualified to do this. Get an HR person to analyze these things and give us an answer. And you say that was not done.
It was not done. Yeah, Commissioner. It was not done.
Thank you.
And I agree with what you're saying, Commissioner, that looking at the functions, the question of interpretation, some of these responsible for valuation of statistical data, and these are not
Chair,
functions that you can do.
Chair has just directed me on 909.
909. yes.
One of those bullet points, I think it's number 5. It says leads special projects and technical related project teams.
Yes,
That's a leadership role.
it is. Indeed, it is.
Advocate Balwa is referring me to another one, so it's the same one. Oh, it says from all departments and levels, including management. Do you see that?
Yeah. I see that, Commissioner. In fact, the majority of them, Commissioner, if you look at the being responsible to initiate and follow up on corrective actions, time and cost-wise, most of these management-related.
So
And
most of the functions she was performing at BMW for a period of 7 years are of a management nature, although she did not occupy the official title or official position of manager.
I agree.
Because when you direct, control, and oversee, whatever your role is, you are managing. You are responsible for projects, you are responsible for people, you are responsible for ensuring that things get done.
Indeed, Commissioner.
So the question asked of the BMW person was a wrong question, because what he was asked was she a manager at BMW?
Yeah.
But that's not what the advert requires, and that's not what the national instruction requires.
Indeed, Commissioner. And I think maybe to add on what Commissioner is saying, they also underplay this role where, and I think it's common cause between her and Mr. Seyman, that she was having about 15 people that she was supervising, or at least teaching. It cannot be, that task cannot be given to the most junior of your officers.
Yeah.
Or even if you do, that comes with a lot of responsibility, that you trust the person and they're imparting knowledge and skill. It's also a management function.
The mistake they made was not to show Mr. Simon the national instruction and to say to Mr. Simon, please tell us what Ms. Mokwele was doing at BMW. Is it experience at a level higher than the supervisor? And what were those functions? What they went there to ask was she in senior management for 7 years? That's a wrong question.
True.
And to then go to court and say she must be arrested for fraud because she doesn't have 7 years senior management experience. Before we even get to the charge sheet, just asking the court to authorize arrests on those facts, that is problematic.
I concur, Commissioner Kumali. These are things that it goes back to my earlier position that the investigation was rushed, or at least the arrest was rushed. These are issues that ought to have been dealt with and determined before arresting.
And to your credit, once you saw the docket, you asked these questions.
I did, Commissioner, because a lot didn't make sense, really. And I was worried that people have already been arrested. And not just you, not that any person has to be arrested, but the most senior people in the police, and at a very sensitive unit for that matter.
Mrs. Serunye, you may well have answered in your way you started in this discussion with Commissioner Khumalo, but I just want to be clear about the position that you express in paragraph 54 of the statement. You raised a question on whether this matter fell within IDEC's mandate. But then you go on to say that you considered a matter of this seriousness involving senior officers in the intelligence environment to be one that can be appropriately handled within the IDEC space. That's a bit confusing for me. What are you conveying? What are you saying in paragraph 54?
Yes. Commissioner Baloy, as seen on the other email with the Lushaba matter, I questioned whether this fell within the IDEC mandate. When one reads the docket right from the onset, you're seeing offenses, fraud, but then you go deeper into the merits. You don't have evidence. But that is why the first question is, does this really belong here? But if you were to follow these queries or find evidence of, let's say if they followed the queries, or even before I asked, they did an investigation and they found evidence of corruption, then I would have said, then that's where it comes up to say that if you look at the role and rank of the officers, maybe. I don't expect the district and regional courts to can handle a matter of that nature. But the problem is there was no evidence to back it up, to say this case belongs here. The allegations are serious when you hear of them, but once you start reading the docket, you don't find evidence to back those allegations. So if there was evidence of rigging of the applications and the lawful appointment of a person who was going to occupy a position paying her over R1 million a year, and there was collusion with the police, definitely it would have met the criteria of the IDEC. That is what I'm trying to say in the thing. But the problem is that there's no evidence. Even if one were to say we're transferring it to the lower courts were still going to sit with the same problem of, but where's the evidence to prove all these allegations?
Is another way, I'm just trying to understand what you were saying here, is another way of what you're saying in paragraph 54, that if the allegation of, because this case is about gratification, that's how they formulated it.
It's true.
Are you conveying in 54 that if we can make out a case for gratification considering that it involves these senior officials, the matter would fall within the mandate of the IDEC? Is that what you're saying?
That is the message I'm trying to convey, Commissioner Baloy, that it would have been meeting this requirement of corruption involving high-level persons to a point that it then falls within the mandate of the IDEC.
Okay.
But it didn't come close to that. At least with the evidence, I would have expected right from the onset the person who read the docket or those, after compiling the evidence, once they said and presented, a decision ought to have been taken there and there to say, look, let's refer this matter to the lower courts if there's evidence of prosecuting somebody with anything, because it doesn't also help to refer the matter to the lower court to say, deal with this problem for us. There's no evidence. See what if we can make a decision ourselves at IDEC to say there's a case or there's no case. If there's no case, we close it, we make our report why we're saying there's no case, and we file the documents. If there is a case, then we prosecute. But there was, for me, there was no evidence backing up those allegations.
Now, Ms. Johnson was asked more than once whether the way things developed
Yes.
up to the point where these generals and brigadiers are arrested and then presented to court, and they're getting these postponements, ongoing postponements, whether no one in the office of the lawyers, an office which has many lawyers, whether no one ever raised concerns about the strength, whether this matter falls within ADEC's mandate, but two, the problems that we were discussing with her. You've discussed some of them with Commissioner Khumalo. What is gratification? Ms. Mokwele seems to have met the requirements. How do you have a charge of corruption under precar gratification when you say that she would have done something in the future which is unknown? All of those were discussed with her. And then she was asked more than once, does this mean no one in your office ever raised concerns about this case, the merits of this case and the mandate of IDEC? And she firmly said, no one ever did. None of the lawyers. What do you say to that?
With respect to Advocate Johnson, I did. I raised, I think earlier we read one of my emails where I referred these queries to her. And it was not only that one email, but there's two, maybe even three others that I referred to her, where even with the Lushaba case. The Lushaba case is worse. That's why I'm saying. So I did. I don't know if
so she was not being truthful.
Maybe she did not have my email communications to her, but I did. I raised my.
Do you have reason to doubt? Do you have reason to doubt that she received your emails and your memos? Is there
she received them.
She received them.
I can confirm, because once I send an email, Innocence, and there's one email, for example, where she responds to me when I'm asking her, should we serve at 28, or is this office, referring to her office, going to write a letter to the National Commissioner? I send it to Innocentia, but the ID then responds to me, says serve at 28. So, and when I send an email, and this is the practice in the office, to the PA, if you see that you're not getting a response, you make a follow-up with the PA. Did you give my email to the ID? Sometimes you go straight to the ID's office, or call, or send it.
So in short, she did become aware. She was made aware of concerns about this case, the Lushaba and the Mokwele matters.
She was. I did that personally.
And she was not truthful to us if she did say to us, as I say she did,
yes,
that no one in the office raised concerns about this. She wasn't being truthful.
Commissioner, if that is what she said to this commission,
then she was not being truthful.
I don't agree with that.
Okay. She was not being truthful.
She was not being truthful. I'm saying that with the utmost respect.
I appreciate. I understand that. Thank you.
Advocate Serunye, I want us to put away file 2, but before we do that, there is a standalone allegation that a young woman has been parachuted to the rank of brigadier. And I think Mr. O'Sullivan, when he was here, made that allegation, and it's one of the things he wants us to look at. So on 178 still, of file 2.
I have it, Commissioner.
My understanding of item 3.2 is that the moment you get a suitable person from outside and you appoint them as section head, technical support services, what then follows is that they will be given the rank of brigadier.
Yes.
So And you get that rank because you are appointed to this position, not because you are 43 or 26
That's true.
or 35,
Yes.
or you are male or female. That does not matter. If you meet the minimum requirements, you go through the interviews and you are vetted and you get appointed to this role, you will be given that rank and you will become brigadier.
That is true, Commissioner. The advert was not referring to a specific race or gender or age. In fact, and I'm trying to look at this thing again. I think, if anything, it was trying to promote. I just want to see on the advert. I think it would have, if it's talking to promoting. Okay, it's not there, but I think
It's in the national instruction.
it should be in the
What you
national
are looking
instruction.
at is in the
It should be in the national instruction. I've
Yeah.
seen it somewhere where, in fact, it's encouraging
It's encouraging that you promote females.
that female
And, yeah,
persons be considered.
It's in
due
the
to
national instruction.
Indeed, Commissioner. But the fact that she was of a certain age, female, it's not
So
amongst
the
these.
point is simply this: if you meet the requirements and you are appointed to the role, it cannot be a fraud or corruption that you are given this rank of brigadier. It follows as a matter of course, once you have been offered this job and you have accepted it, that you will be given the rank of brigadier.
Indeed, Commissioner. And maybe to add on, the fact that she was competing with experienced colonels and members of the police who have been in the same environment doesn't mean if she performs better than them and she scored higher than them, then that means there's something wrong. We don't know what questions were asked, technical questions were asked, and she might have performed, or she performed. On paper, she performed better than them. Therefore, it doesn't.
Between you and me, and you would know because you are an advocate, there are 30-year-olds who sometimes perform better than me.
Indeed, Commissioner. Indeed.
And I'm sure you've been in matters where somebody a lot less experienced, less junior in terms of years, on the day performs better than you.
It happens. That's the nature of interviews, Commissioner. It's how prepared a person is for the interview. How much they prepare and how you perform. Person can freeze on the day and another one performs better. It doesn't mean we were supposed to take the cadre because the advertisement was for both internal and external people. Therefore, the fact that the civilian was appointed, there's nothing wrong with that.
I think we can put 3 and 2 away now because we've covered file 2 and 3.
Indeed. So, thanks, Commissioner.
Advocate Serunye, just before we move to the next section on the charge sheet, just to understand, did anyone in the team then respond to your email of the 17th of August? Now, this is the one that was sent to the whole team.
Yes, I think I did get responses from either Mr. Brian Parayashi or one, remember Mr. Pat Mlamba, who would have said, thanks for the advice, we'll do as you raise. The issues that you're raising will follow up on those. And I think he said something along the lines that we're taking one on the chin, Prapita, but then I said, it's not like, we're not fighting or anything. It's not in bad faith, but we have to be ready, prepare this matter for court. So yes, I did get a response from promising that investigations are going to be done as I was raising issues.
Okay. And then just to understand your approach in this regard, so at this point, you would have seen the docket, the complete docket. You would have also then given feedback to your team about matters for investigation. The investigators would have also then responded to you, in part not answering, and in other respects trying to give you a better explanation. So you are now at a slightly better position. Ordinarily, when do you call it When do you say, I've looked at the docket, I've given direction on investigations, I've received feedback, this is not getting better? When in the process do you call, assuming that this is an anomaly, ordinarily you wouldn't be here?
Yeah. If the problem with this is, remember now, from the 16th of September, I'm no longer part of the case. I submitted a memo on 16th of September to recuse myself. So I didn't go all the way with it, but I know that some of these queries still remained, and I cannot say now what is the position with the docket. But if you're asking me if I was still part of the case, because I came afterwards, I raised these questions, not getting positive answers. I raised questions again on the second trial note and maybe on the third. I wouldn't have proceeded with the trial of this matter when there's so much still outstanding. Otherwise, it's going to be an acquittal. You're not even going to jump the 174 stage. The defense was, in fact, I doubt even if we're going to start with it. The defense was going to query the charge sheet right from the onset, and I'm saying it somewhere, Section 85. They would have gone for the squashing of the charge sheet as it was. If I succeed in that, and then I'm risking starting a trial which has so many gaps. Lead one or two witnesses once you close your case, and then there's an application for 174. There's no way that we would have succeeded with that. I wouldn't have proceeded with this trial, or started the trial, if all of these issues were still outstanding, if I was still the prosecutor.
Can I just ask, and again, part of it is to understand what processes were followed here and how that accords with the law. You probably would have heard when Ms. Johnson was testifying, there was a debate at some point or a discussion with her about how Section 2813 was used and its purpose. And the concern being that it appears it was used, it was abused, it was misused, basically. Now, I'm looking here at your email of August 17. Now, we know that by August 17, the matter was already in court because these people, so it seems to me in the way that I've understood your processes, and you can correct me if I'm wrong. At this point, 17 August, your 2813 process happened, and then it was followed by your 28-1A decision to investigate. So you've done your 2813 and you go to 28-1, and then there's a J50, and then people are now presented to court. By all appearances, or from what you're explaining, by that stage we must have completed our investigations. That's why we are in court. And yet your email of August, your emails, in fact, let me say emails of August, they're still talking about investigating.
Yes.
And I'm looking at your page 53 in particular, the very last paragraph of that email of the 17th of August. Well, maybe before I do the last paragraph, you say that we should therefore not try to convince each other. Before the preceding paragraph, you say, once the alleged conduct committed does not meet the definitional elements of the offense, as I'm finding it to be in this case, that means no crime. In brackets, you say corruption has been committed. So we know that at the 17th of August, you held that view and you expressed it. And then in the last paragraph then, you say, having said the above, I'm still of the view that if we investigate further and dig more, we are going to find the evidence of corruption of the general by Mokwele and not vice versa. our answer is in the bank statements, cell phone records, and computer data of the generals. There's no way that these people did not communicate prior to advertisement and during/after the interviews. If the generals gave Mokwele a job she did not deserve, it is for the particular reason, and we must find out this reason. Did she bribe them? And then you ask questions. You conclude what was the quid pro quo for the generals to act in the manner they did. Now, in this paragraph, firstly, what I have a difficulty in terms of how I've understood your processes is you are past section 2813 because there's been a decision.
True.
To investigate. You investigated, now you've charged. So you're now in the realm of court. And you, DDP, hold the view that as matters stand, we have nothing. And then in the last paragraph, you say, let's go search. And it seems to me that now what's going to happen with that last paragraph is to meet or satisfy a theory that has been formulated. We have nothing to work with, but our theory is these generals are corrupt. Let's go find something. And you can explain it. And if that's what's happening here, it seems to me that even on your own email, you are participating in an inverted process where what is the stage of things? You are in court. These people are appearing. Why are you saying we don't have a case, but I'm sure if we dig some more, we'll find something? That to me, on the face of it, is deeply problematic, but also your position, it's inconsistent with the position that you take earlier on where you say we don't have a case. And then you say, but I'm sure if we search, we'll find something. That's not like a typical fishing process. Can you just explain how to make sense of your contradictory positions and what I suggest is a fishing expedition that you're suggesting should happen? And it's not simply a fishing expedition. It is in fact an abuse of your investigative/prosecutorial powers.
Thanks, Commissioner. Commissioner, I came into the matter after arrests have been made. These emails, especially that paragraph, I'm still raising questions. I'm still saying, but why are these people arrested? I'm saying to them, investigate. Dig some more is investigate, which I said shouldn't happen. We should investigate, finish our investigations. Once we satisfy that we have a good case, this is the prima facie case, then we go to court. In this case, it's vice versa. I'm coming in after the fact. I'm trying to rectify wrong things that have been done by saying, do your job, do what you ought to have done right from the onset. Looking for information is like investigate. I'm asking them, did you look into the cell phones? Did you look into the computers? Did you mirror image computers? So I'm playing that part which ought to have been done right from the beginning. And for me at the time, all this does not make sense. I'm still asking myself, how did this matter get to a point where it did? But do I have powers to say, there and there, we're cutting this off? Or should I first satisfy myself that indeed there is no evidence, and then only then call it off? It's a pity we don't have some of the emails where I keep on saying, I'm going to write a report at the later stage to the ID because I could see that this thing was started wrongly. So I'm not saying dig for something that is not there. I'm saying investigate. Digging for information is investigate. And if you find the quid pro quo, then that's your solution. That's your solution. But otherwise, there's no evidence of corruption here.
Let me ask you this. Was it, and I ask this, I'm not particularly familiar with the NPA Act,
yes,
and the powers that it gives. would you have had the authority, considering the Act, as DDPP? Would that, you may not have exercised the option if you had it, but is it one of the options that ordinarily are available or within your powers, where if you came in the way you did, you came in late, things had moved along, and you have formed the view that you express, where you say we don't have a case as matters stand, is it within your powers to say, let's stop and go back to the drawing board? I know you say people must go investigate, but I'm asking a bigger question, as in, you have people who are under bail conditions, who have been told they may not go to their offices anywhere in the country. You have people who are appearing in court, being postponed. So there's a disruption to some people's lives. Is it something within your powers that you could have come in and said, hold off, let's stop what we are doing, let's go back to basics and start from scratch, and we are not going to court, whatever we have in court, we are going to, I've heard of, it's not a withdrawal, it's something, removal from the roll, which is not a permanent withdrawal of a matter. Does that kind of power lie in your hands as something that you could have done here?
Yes, Commissioner, and that is why I was asking, we should remember this is maybe 9 days after I've become part of this is actually the second document that I'm writing to them to say, do the following. But like I earlier said to Advocate Bowe, if this had persisted up to a point, if I was still a prosecutor, up to a point where the case, I would not have prosecuted this case. At some stage, I was going to call it off. Unfortunately enough, just a month after, I then got off the case. But I couldn't, just on a week or 2 weeks after getting into the case, and say, no, let's withdraw this. But it is after testing what was the basis of starting this whole thing, and I realized there's no evidence. There was no basis for this. I should have done that. Maybe after consulting with the ID, sit down with her and say, look, this is the position, this is the evidence, I've read this, these are queries I raised, they are still unanswered, there's no evidence. At some point, I was going to get to that point. That's what maybe one is in management for, to raise these issues with the...
So Advocate Manilal, who succeeded you in this position and who has overseen this matter after you recused yourself, and on the assumption that up to when Ms. Johnson was testifying, Advocate Manilal was responsible for this matter as the DDPP. He has, what you're saying is he's got that power. He could at any point, after your many notes and his own observations, he actually does have the power to say, let's stop this, even if it means let's go and redo the work. But let's stop what we have put in motion. He has the statutory power to do that.
He does. Just like I have those powers. He does. But like I said earlier, I don't know at what stage he was appointed. And what I know is, with the evidence of the former ID 2 weeks ago, we got together, me and Manilal and Hlachwayo, and the two other prosecutors who were now part of this. And our decision was, based on what came out after the evidence of the ID, there's no way that this case can be saved or resuscitated. And we then asked for a meeting with one of the deputy directors, national deputy directors. We met with her and we said to her, we know now that the matters are seized with the NDPP, but this is our proposal. And I forgot her name now. I think it's Advocate Bell. And I know that Manilal thereafter penned a memo to them based on those discussions with Advocate Bell, setting out our views. And then we were overtaken by events where I heard that the NDPP has decided that the cases must be provisionally withdrawn. Yes.
Thank you. Thank you, Ms. Bond.
Are you saying there was an independent review by IDEC separate from the one by Advocate Mutibi's team?
There was by the old and the new team in IDEC. We did need
the IDEC team.
Separate
the
from
IDEC team.
yes,
Okay.
that's correct, Commissioner.
Yeah. No, you don't have to go into the details.
Yes.
I just wanted to be clear that
There was a
two
separate team,
processes.
my team and the team of Manilal. We met and we agreed that it appears we're flocking a dead horse.
And in that kind of decision, at that point, what is the role of the DPP? It's the DPP, I think, from the evidence of Ms. Johnson, she submitted the charge sheet to the DPP. DPP says, I agree with your decision to prosecute. There was that kind of discussion. When you get to this point where you are now reviewing and you finally express the view that this is a dead case and we know how it has played out, the DPP's role is what there? Do they participate in that discussion? And
Commissioner, the DPP did not participate in that discussion because the DPP is sitting at the provincial office, DPP's office. We are separate IDEC. I'm not sure if our communication, the memo that was penned down by Advocate Manilal after our discussion, which was forwarded to the NDPP, if the provincial DPP Gauteng has been copied, but the DPP was not part of these discussions.
thank you.
The DPP's role would have, I believe, ended when they were doing consultation with the ID, and where, because the ID wants to prosecute in the DPP's space, there must be that consultation, and I believe it happened in this case, and the DPP would have agreed, but the role of the DPP ended there.
And on the question of now, we are reviewing and we are, if it is a withdrawal, forgive my use of the word withdrawal, I don't use it in its technical sense, but where the decision is made to remove the matter from court, you're saying the DPP, as far as you know, doesn't get to play a role in that. And I ask because from the evidence, once the ID, and you know this better than me, once the ID has made the decision to prosecute or to prefer the charges, that charge sheet was sent to the DPP, and the DPP wrote back and said, yes, I concur, or something to that effect. So that's why I'm asking about, now that you're changing course, does the DPP get to look at this and say, yes, I agree that we really are bad, or they just hear from the client being IDEC?
Yeah. In this case, we did not involve the DPP commissioner, because from what we gathered, the matter was now already in the office of the NDPP. That is why we wrote directly to the NDPP asking for a meeting with them, and we were then allocated Advocate Bell to meet with us, and the discussions took place between us and Advocate Bell, who was representing the office of the NDPP. But I understand what Commissioner Balo is saying.
Yeah.
Ideally, the DPP, in a way, ought to have been at least informed. The DPP in 2025, May or June, we consulted you on this matter, and we informed you, we prosecuted, you agreed with us, and we have since taken another decision. I want to believe that ought to have been done. And we went straight to the head office.
Yes. And the ID in that kind of situation that you end up finding yourselves, where you Mr. Manilal and somebody else are now looking again at this case. What is the role of the ID, if any?
Yeah. Commissioner should be remembered by that stage, that's when the ID was testifying. I think our meeting with the NDPP's office took place either on the Friday or the very first, or last week Monday, when we heard that the ID has resigned.
Okay.
I think that, yeah, so she was no longer, she couldn't take part in those, because in any event she was still testifying in the commission.
Well, I guess my question still remains, ordinarily, would the ID have to approve your decision, or this is a purely prosecutor's decision that are seized with the matter and they make their decision?
No, if she was still there, she would have to approve it. We were supposed to sit with her, pitch it to her, show her reasons why, and once she gives that approval, then it can be done. No prosecutor can withdraw the case in the ID on my own, going to court and just withdraw. Even if something happens and I'm in court, say the court maybe is refusing me a postponement, I must let them know. I'm having these challenges. There's nothing I can do. The matter is struck off, but it must be authorized.
All right. Thank you.
Advocate Serunye, let's then go back to your statement. You are now dealing with the charge sheet and your efforts to amend that at paragraph 55.
Okay. At 55, yeah, like I said earlier, the charge sheet as it stood at the time I became involved did not make, in my view, make sense. My principal difficulties with it were the following. First, the corruption counts inverted the giver and the receiver. One count charged accused number 7, Ms. Mokwele, with corruption on the basis that she had agreed or accepted the gratification in the form of an appointment. A further count charged the generals with corruption on the basis that they had given or agreed to give that same gratification, being the appointment, to her. On the ordinary structure of Section 4 of PRECA, the public officer is the party who accepts and the private person is the party who gives. Here, the pleading had the public officers giving employment to a civilian, which is the reverse of the concept, and critically did not identify any unlawful act which Ms. Mokwele was to perform in return. Secondly, a further corruption count appeared to be a repetition of the count against accused number 7 being directed against her in respect of the same gratification. Thirdly, the fraud counts gave rise to a contradiction. One count alleged that Ms. Mokwele had misrepresented in her curriculum vitae, whereas that its contents were true and correct when they were false. A further count alleged a like misrepresentation in her SAPS application form. And a further count alleged that the generals had misrepresented to SAPS and to the public that the selection process had been conducted in accordance with the applicable instruction. The difficulty is that these allegations cast the generals simultaneously as the victims of Ms. Mokwele's misrepresentation and as the perpetrators who had rigged the process in her favor. The same persons cannot be both victim of and the parties to the fraud. If, as the charge sheet alleged, the generals colluded to appoint her, they were not deceived by her. The conduct would not be fraud of that kind, but at most a conspiracy. It was for these reasons that I settled the amended charge sheet.
But would it not have been fraud against the state, not necessarily the generals?
Indeed, Commissioner.
Assuming that all things were equal, of course.
Yes.
And based on the questions that my co-commissioners have put to you, it appears that that was not the case. That is, it was not the case of all things being equal.
Indeed.
But assuming that all things were equal, is it not so that the fraud would have been committed as against the state and not necessarily the generals?
Indeed, against the state as represented by its officials being the generals. So ideally there would have been witnesses then in the fraud case. My view that the matter was rushed was communicated. I'm reading from paragraph 60. My view that the matter was rushed was communicated to the ID on 25 August 2025. My views are set out in Annexure PS10.
Just one moment before we move on. At paragraph 59, you reference the amended charge sheet, and that's at page 54, PS6 of your annexures. And the charges that you had amended are at page 69 of that charge sheet. Just in relation to this charge sheet, was it ever, what came to be of it? Once you've drafted it and shared it with
It was
the team?
disclosed. Remember, we were under pressure now from the defense. They had asked for further particulars, asked for a copy of the charge sheet. They were never given a charge sheet, or at least the only charge sheet they had was the one that was used during the bail proceedings. So around September, they are now asking for a final charge sheet, and they were submitting a request for further particulars. So it was disclosed to the defense.
So this would have been the charge sheet that would have gone to trial if it had? Or the closest, if barring another amendment?
True. If my queries had been answered, if I was the prosecutor, yes. But those who came after me, they have a right, as long as the accused has not pleaded, they have a right to ask for an amendment of the charge sheet. They can always change it. The only problem is if the trial has already said the accused has pleaded and you have laid evidence. Once you have laid evidence, then you can, the least you can do is to ask for amendments on certain portions. But the prosecutor comes in, they can always, when they are not comfortable with their colleague's charge sheet, ask for the charge sheet to be replaced with a new one based on their understanding of the case. So I was on PS10 where I penned an email to the ID informing her that my view is that this case was rushed. And that communication is on 25.
Can I just understand? At page 69, you say this is the amended charge sheet. It has only one count, if I'm reading it correctly.
69 of my affidavit.
Yes.
Yes, that is true, Commissioner.
Okay, because so this is a move from the charge which has 7 counts, because we've been discussing we've discussed with other witnesses, including Colonel Pareachi,
Yes.
on the basis of a charge sheet that has 7 counts. You're saying this is the amended one. This is
the
version 2.
That is true, Commissioner.
And it is before the court, and it was disclosed to the parties.
It was disclosed to the
accused.
Yes, to the accused.
Yeah. I see Ms. Poe wants to testify.
No, I don't want to testify. I suppose my confusion is that in the docket, this one isn't there. So we operated on the assumption that this was a proposed amended one, but that never saw it to pass. So this is the first time in testimony that we are learning that this is the one that was actually disclosed. And unless the team that came after produced another, this would have been the one, the operative one.
No, this charge sheet with its preamble starts at, I think it's at page 54. This is the charge sheet that I drafted. Me and at the time, it's only me and Advocate Tlachuayo, the team. And otherwise, if I involve investigating officers on the Mokwele Kumalo charge sheet. This was disclosed to the defense.
And you know that for a fact.
I know that
this was disclosed to the accused.
Indeed, I know that for a fact. In fact, I think I'm the one who sent the email to one of the attorneys, who represents accused number 2, who represents Mr. Lushaba of this charge sheet. And thereafter it was then sent to the other attorneys.
Advocate Serunye, if you can just make that email correspondence available to us.
I'll do so.
Let me ask then about this one, that you say in that first paragraph, you set out what is supposed to have been done by the accused, and you say, acting in furtherance of a common purpose, did conspire with one another to give or offer to give gratification to accused 7 for the benefit of accused 7. I'm battling to understand, given your position, your correct position, I thought, that you have taken that, but the way that they are formulating the charges, they formulated the charges is they've inverted the position. It would have been for 7 to give gratification to these other officers, but you seem to have gone ahead anyway. Unless I don't understand this, you've gone ahead to formulate a charge that says they gave her gratification.
Yeah. Yes.
What? And I'm not asking about the merits of this. I'm asking about, because you would have heard from evidence that, rather, when we were engaging with Ms. Johnson, that there was a question of, but why was this done? This which looks so obviously wrong. Why was it happening? Commissioner Kumalo went so far as to say there's a third, either he said there's a third hand or a hidden hand, it looks like, because things don't make sense. How this team of investigators and lawyers would do something so obviously wrong on the face of it, and that doesn't make sense. If I read paragraph 1 or understand it correctly, you're repeating that which you've criticized. You can correct me if I'm wrong, but you seem to have repeated that which you criticized by saying they granted gratification to Brigadier Mokwele. And I'm trying to understand, why would you craft a charge like that?
Yes. Okay.
If your position, as I understand it,
yes,
was that is nonsense to charge her with gratification, or her or them with gratification.
Okay. True. Okay. Thanks, Commissioner. It's not a repetition of this section 4, which they were alleging, and which, in my statement, I'm saying is defective. I drafted this. It's pending the investigation outcome of what the investigation is going to uncover. But my logic in this is, and commissioners will see the misrepresentations that we are alleging on the alternative count of fraud. For example, if one looks at the misrepresentations, the first one on page 70. Because I said conspiracy, section 21, they conspired, all 7 of them, alternatively fraud. Our understanding at the time is, if the evidence that we are alleging, that the application of accused number 7, Mokwele, was submitted late, because we were going to call a witness who was going to say, this application was received on the 26th, yes, which the closing date is the 25th of April. Her application, its date stamped the 26th. The witness would have said it was received a day later. Therefore, without going into the other misrepresentations, if the panel members know and can see that this application has been received a day later after the closing date, why didn't they disqualify her? And by not disqualifying her, they acted in colluding with her, they're conspiring with her to commit what I can only sense at the time that she be given this position. That is how the conspiracy comes in, to say, if all of these presentations that I'm alleging here, our understanding at the time that she had said, I'm a medal manager, if what we went through earlier with Commissioner Kumalo, if all of those were then found to be true, that the last one, for example, of the presentations, where accused 7 meets with one of the panel members, I think it's General Ngube, should be Ngube, a day before the interviews, accused number 7 meets with accused 6, Pindile Ngube, who helps her to apply for security vetting. They then use the Inkwazi system, which we are told is meant for service providers, because she couldn't be loaded onto the prescribed SAPS system, because at the time she did not have a personal number. That is only reserved for police officers. People are already on the system. Now, accused 7 and Ngube then decide they register her on a thing. So that in itself, a day before the interviews, there is this collusion, and her advertisement, according to us, is received late, and according to us, she does not meet this managerial experience. Well, we can drop that now, but at the time she was not. Therefore, if you look at all those things and you're asking, how could this panel of generals in the intelligence service not pick up all of those things, and even the fact that one of them was with the applicant a day before, the only thing that one could argue before a court was they were colluding with her to commit an offense under Section 21.
Yeah, I can see, without commenting on the merit of it, I can see how you would list all of those things under your alternative count of fraud. So that's not my issue. My issue is the preca, the main charge, and it gives me a sense that, and I'm seeing this amended charge sheet for the first time, keep that in mind, but it gives me a sense that you have that main charge under preca because you are forcing this case to be under IDEC. It has to be a preca offense. Even if we can't prove it, we lose, but at least we have the alternative. So instead of starting with your alternative, making it the main charge, which I suspect, it much more obviously raises the question, why is this an IDEC matter? You know, why if it's a fraud and you're listing HR matters, because it is HR matters, about meeting the requirements for the position, So I don't understand the preca decision, and with you in particular, because you hold a view about this, and then you go and formulate the main count in the way that it has been formulated. I don't think you believed it. Otherwise, you have to explain all the other notes that you've been writing and the questions that you've been asking about this. I don't think you believed that this case falls under preca. Then the question becomes, well, what compelled you to make? Was it to make the ID happy? Was it that you don't want to rock the boat because you were brought in when you did and you found things to be what they are? When you have expressed very strongly that we don't have that kind of case. Can you just explain that? I appreciate that you came in, tried to be the voice of reason. And maybe Ms. Ramsame and Ms. Tlachwayo, if she does ever appear, will come and tell us why were they not discussing these things with you once you raised them, and why did they not warn their bosses and their investigators? But you hold a view from the outset after you brought into this matter, and you're consistent about it. And then when you get the opportunity to amend the charge sheet, you could have used the alternative to be the main count. You would have a debate about, but is this an IDEC matter, which is not the debate we're having now.
Yes.
But why do you appear to force a preca count in this charge sheet?
Yes. Thanks, Commissioner. I was not forcing it, Commissioner. I was not trying to please them. I speak my mind out. Everybody knows that. I was saying investigations are still outstanding. Cover these things up. But if the little that you have in the docket is believed, if indeed Mokwele's application was received on the 26th, then she ought to have been disqualified, and she was not. And if she's not disqualified, then she's being favored. By whom? By the panel, because the panel seats, they have all those 76 applications. Then people are disqualified one by one for not meeting the requirement. But why is this one, which is received a day late, gets to a point where she's shortlisted to top 5 and then to top 3? That if her application was received a day late, it's collusion with the panel members.
Why do you keep saying if, as if there was no evidence when you were drafting this charge? No. It was something that you still wanted to be established.
No. Commissioner, it was there. I'm talking about the receiving of the thing late. Her application is date stamped the 26th. I'm saying if I were in the court, addressing the court, and the court were to believe me. But again, the one thing that was not there, one of the issues that I raised in one of my emails was, go and obtain the affidavit of the secretary of the panel, because that's the only person who can talk to when was this application received. And that was done after I had left the case, but I'm told that affidavit is there and the person confirms that the application was received on the 26th. Therefore, she ought to have been disqualified. And that is why I'm saying if the evidence were to be believed and that her application was received a day later, she ought not to have made it to top 5 and to top 3 and ultimately to top 1. And that is why the collusion. Section 21 talks of conspiracy to commit the offense of preca. Section 4, which was drafted earlier, talks of a public officer being given a gratification by another person. Section 3 is a general offense of corruption, which can be committed by anybody. Maybe if they had drafted their indictment in terms of Section 3, much as I was going to ask questions, but where's the evidence? Maybe I was not going to say your charge sheet is defective because it's putting things the other way around. The giver is said to be the receiver and vice versa, if they went for Section 3. But I was still going to ask the questions that I asked. Where's the evidence to prove your corruption? But if I'm going conspiracy because I'm looking at these pieces of evidence that the applicant meets with one of the panel members a day before. They try to put her in the vetting system. They can't do that because she does not have a personal number. They then register her in a system called Inkwazi, which is meant for service providers. What do I call that? Looking at the evidence, she's colluding with one of the panel members, at least Mube. If her application was received late by a day, it ought to have been disqualified. She's colluding with all of them. They conspired to commit corruption based on the evidence that was before me, and that charge made sense in that way.
How was an outsider like her supposed to be vetted then?
Sorry, Commissioner?
How was an outsider like her supposed to be vetted?
On the reading of these...
Because you said, for example, because she was not on PESAL,
yes,
she couldn't use the vetting system used by those applicants who were internal within SAPS, that is. So how was she supposed to be vetted?
only at the point where if she had been appointed, the moment she's appointed after passing the interviews and she's appointed, then they give her about 6 months to do the vetting. In that 6 months, now she has a personal number. She can be loaded onto the SAPS vetting system, and then she does the vetting, or she can do a private.
Continue.
Sorry, Komsa. She couldn't use the SAPS vetting system because that you can only do when you have a personal system. Secondly, the use of the inquiry system, it's fraudulent in itself because it's meant for service providers.
But do you include her in that? Is she supposed to know anything about Inkwazi and whatever else if it's not Inkwazi? Is she supposed to know that?
I don't think she would have known that, but now she meets with one of the panel members a day before the interviews and taken through this, and she submits an application, and her application is processed. And based on
That's exactly my question. Is she supposed to know that that ought not to have happened? Because if vetting is mentioned and all of this is taking place, and from where she was sitting, that was an attempt to satisfy the vetting requirement, or not?
That's true, Commissioner. I don't think for her, the civilian, she would have known even the difference between the SAPS vetting system and the INGWAS. But here's one of the panel members who's taking her through.
You see, my question does not relate to SAPS members.
Yeah.
It relates to her. Should she have known anything about any of this? That's what my question is about.
I doubt that she would have known. But if we arguing the matter in court, it's something different. How did she know that she has to avail herself at the office of Ngube, where she has to be taken to the vetting office for the vetting to be done before the interviews are done? The interviews are going to be done the following day,
okay.
And they can't do it.
Let's leave it there.
Advocate, you may not know this, but all the shortlisted candidates were given a letter to say they must make themselves available for the purposes of vetting. So they were actually being disadvantaged because the advert said you must only do that 6 months after appointment. So whoever said to them, come and do it before the interview, was not benefiting them. They were actually disadvantaging the candidates. Because the advert is the one on 178 file 2 that I took you to. When you do that, you're not benefiting the candidate. You are actually disadvantaging the candidate because you are subjecting them to a process that the requirements do not provide for. And it applied to, because it's that letter that General Khan even said, well, I don't know anything about this letter and all of those. But Commissioner Baloyi's question remains. You said there is no breaker offense here because after gratification, or rather gratification must be given. And then you said in brackets or in inverted commas, in order to. And you said because the in order to is missing, you cannot sustain a charge under breaker. Now, Commissioner Baloyi says, if that was your position, why do you then draft a charge sheet that still includes gratification? Because even if you go to Section 21, all Section 21 says is that you conspire to commit the breaker offenses. So it takes you back to the offenses, which means your gratification must still have that condition that it is in order to do something. So if they had conspired to give her gratification in order for her to do something in return, then that would have been fine. But as charge 1 stands now, the main count, that in order to part is not there. So why do you still have a gratification offense if the remaining elements of it are missing? Because you can't just say you have conspired to give somebody a gratification, full stop.
I understand that, Commissioner. Maybe then, instead of Section 21, one should have raised the Rioters Assemblies Act, conspiracy in that old act. But I'm saying we're coming to the conclusion of conspiracy based on these pieces of evidence that things were not done properly. A person who ought to have been disqualified because the application was received late was not disqualified.
But that's the alternative charge. That's not the main charge. The main charge says you conspired to give a gratification. Full stop. And Commissioner Baloy's point is, you've already said that gratification must be followed by something else. So if your main charge does not have that something else, then it contradicts your memo where you said, absent that something else, there is no charge. I get your alternative where you say the alternative count has a potential of all these things.
Yeah.
But forget about the alternative for now. Look only at count one. What is the offense in count one?
Yes, I see that, Commissioner, and what you're raising is important in that there is that debate amongst colleagues that where we're referring to 21. Does it take us back, like you rightfully said, does it take us back to, because 21 says any person who A, attempts, B, conspires with any other person, or C,
Look at the last part. Look at the last part.
Yeah. Another, to commit an offense in terms of this act is guilty of an offense. To commit an offense in terms of this act.
So it takes you back to the offense.
It takes you back to the act, like you're rightfully saying, maybe a question of interpretation, but the intention at the time is so on hindsight when one says, yeah, but Serunye, still your conspiracy does not fit in.
Yeah. Because look at count one. What is the offense in terms of this act in your count one on page 69? Because remember, it must be in order to commit an offense in terms of this act.
Yes.
Yeah. So what is the offense in terms of this act in your count one?
The act that has to be committed.
Yes. The offense.
Oh, it's contravention of Section 21.
No, but 21 says you commit an offense if you conspire to commit an offense in terms of this act. So it takes you back to offenses in terms of prayer. Look at the last part of Section 21.
Mm-hmm. Yes, I see that, Commissioner, that last portion would then take you back to say if people conspire in terms of this act, they must conspire to commit an offense in terms of this act.
Of prayer,
B, Section 3, 4.
Yeah. So in the charge, where is that offense?
Well, we didn't cite the offense because I couldn't go back to what I was criticizing. I can't say you conspired to commit Section 3 or 4, which according to me was non-existent.
And it's not as if you were not aware that there had to be this something else. Do you remember your very first query when you raised the many questions?
Yes.
You even said to do what? And then you have ... to show that you expect this something. You yourself, when you raise the queries, do you remember that particular query?
I do.
Did it not relate exactly to this?
It does.
It must have. It must have related exactly to this.
I concur. I concur with.
Did you suddenly forget now when you were couching the charge about your own query?
Yes. Yeah, commissioners, I agree, and I must say, there's an ongoing debate. Like I'm saying, now that it's being raised, I remember one of the discussions I had with colleagues in the office. We debated this, we argued about this a lot, and maybe I was for this side, and I can see now that maybe.
Commissioner Baloy says the reason you put it there as the main count is because you knew that if you started with the alternative count, then either does not have, this does not fall within IDEC's mandate. So you had to put PRECA as the main charge to justify IDEC continuing to prosecute this case.
No, I respectfully disagree, because that will then question my motives, and I come in here with clean hands. I came in to rescue a situation. I've never, since I was involved in this case, involved myself in any shenanigans, and I stand here, I can say with a clean conscience,
You know,
I did my work to the best of my abilities.
A prominent South African once said, "My hands are clean," and we know what happened next.
I do, Commissioner, but yeah, for me, listening to the evidence, and like I said earlier, hearing what I've heard here, I wish, and as I was saying to somebody during lunch, I wish I could turn the hands of, back the hands of time, and I wouldn't have gone to court on that day, on the 27th, when there was a bail application on 27th of June, because here I am now, in the middle of something that I did not start. But what I can say is, I realized when I came in that this case was rushed to court. It was not ready. I raised those queries, and I wouldn't have prosecuted the case like this if it was not ready. It's a pity I recused myself before I could make that decision. Otherwise, I would have made it.
I have a generous explanation, attempted explaining what happened with your amended charge sheet. It is, you came in, you found a mess, and you tried to help fix it. And because you knew that they are going for gratification, because that's the more serious charge that would get people in court suspended, and you were trying to fix an unfixable. Is that?
I'll take that, Commissioner. I'll take that.
Thank you.
And indeed, the several questions you ask do show that whatever impropriety there might have been, you were not party to that. Because if you were, you would not have raised the many questions that you raised, and doing so more than once.
I accept that, Commissioner. I quit it. I did not go along with something that was wrong, or at least something that I could see was not prepared thoroughly and ready for court.
Thank you.
And then, Advocate Serunye, in relation to your paragraph 60, which you read into the record prior to the engagement, just to note that you then sent an email to Advocate Johnson directly on the 25th of August, and that's PS 10 at page 93.
I indeed, Council, I sent an email to the ID. If you look at page 93, PS 10, I sent an email at 11:44 on the 25th of August to Advocate Johnson, copied her PA, Ms. Sikukuni, and Mr. Matthew Sissoko, with subject State Visit Kumalo and others. And then I put an attachment. There's an attachment to that email. Trial preparation document 3. I said to the ID, the Kumalo and others matter refers. Attached, please find a copy of my trial preparation note 3 addressed to the team. My view is that the enrollment was rushed. However, there's a prima facie case of fraud, in bracket, not corruption, at least not on the available evidence. Still consistent with what I've been saying all along in terms of...
And then the attachment is at page 95, and you raise substantially the same issues and give directions about particular further investigations and affidavits that should be obtained in order to complete the investigations. That's so?
That is indeed so, Commissioners.
And was there a response to this correspondence, particularly the email that you sent directly to Advocate Johnson?
I did not get any response to this email.
And do you know if she received it?
I sent it to her email, and this time copied her PA. I'm sure she got it.
And then
She did not respond. I don't have proof of that, but I sent it to her.
But you did not get a non-delivery report either.
No, I did not.
And then in an early engagement with Chair, you mentioned that whenever you are sending correspondence to Advocate Johnson where it's less urgent, you would do so through the PA.
Yes.
And an example of that would be on page 24, is that correct? Where you send an FYI to her PA.
That's correct.
And that then with this one where you make direct communication with the ID, are we to understand that it's because it was urgent and you wanted to draw these matters to her urgent attention?
Indeed so. And it was now the third document that I'm writing where I'm raising queries. So maybe in my mind, I was thinking, let me also send it directly to her in case she didn't get the others. But I know, is very efficient. There's no way that she didn't. But this one, I directed it directly to her and copied, as well.
You've also copied Mr. Sissoko. Did he engage at all with this email and report? Sorry.
No, he did not. He did not respond to me about it. He did not say anything to me about it.
And then also prior to sending it to the ID, you had sent it to the team. Did you receive a response in that regard?
I sent it to the team. I would have received one of those emails ensuring me that, okay, no, we'll cover the issues that you're raising. I'm sure I must have received, especially from Brian. Brian is one of those people, when you send an email, he does respond.
All right, thank you.
Mr. Parayashi, I must say, sorry.
Then you move on to deal with the...
Sorry, Council, you'll see in that preparation trial note to the ID, if you look at paragraph 16 or point 16, that's where I'm raising the issue of an HR expert. That an HR expert must be appointed to analyze the scoring of the three candidates and provide a report on whether the scoring of the three candidates was fair and or in accordance with the prescribed manner set out in paragraph 6 in brackets evaluation process of the National Instruction 3 of 2005. Okay.
Yes. Also to point out that in paragraph 5, you say, after receiving input from colleagues and doing further reading on the corruption subject, my initial view still stands. And this initial view you're referring to is that there's no case for corruption.
That there's no case of corruption. Indeed, Commissioner.
Okay. Thank you.
Right. Advocate Serunye, then we can deal with the procedural irregularities that you questioned. You have dealt with the issue of the charge sheet, and the other thing that you dealt with was paragraph 62, which deals with the referral and your multiple attempts to get a copy of the referral, and that your latest one was done when one of the accused persons requested disclosures or further particulars. And there you referred us to Annexure 10.1. Can you then take it? No, I also think you've actually explained the meeting that was called by Advocate Johnson on the 1st of September, wherein she, I guess, questioned why you're not trusting her investigators and that she herself had seen the 27, and so you should proceed with your work. That's correct.
Indeed, that's correct, Commissioners.
Then I think we can take it from paragraph 64, where you deal with when you were eventually shown the section 27.
Okay. Yeah, just in passing, PS 10.1 is an email which I sent to Mr. Sissoko where I was asking about the 27. We're now in 31 October 2025. If I go back to my affidavit, the paragraph 64, some days later, that will be now after the 31st of October, following a management meeting, the chief investigator, Mr. Daylan Perumal, informed me that he had the Section 27 referral and showed me a document in his office. He showed me the document whilst holding it. It was as if he wanted me to see its existence, but not its contents. If I can
what exactly do you mean by that? It was as if you wanted me to see its existence, but not the contents. How did you hold the document? Did you get to read the document? And based on what you are going to say shortly after this sentence, it seems to me that you actually did read the document, because you even estimate the number of pages. And you also suggest that you actually saw the content, because you say it resembled the complainant's statement and basically contained nothing. So you actually read it. So it's in that context that I say I don't understand when you say it was as if you wanted me to see its existence, but not the contents. We know that you actually saw the content. So what do you mean by this sentence?
Thanks.
Or at least I assume that you saw the contents based on what you say about the number of pages and also the fact that according to you, this document said nothing.
Yes. Thanks, Chair. Yes. If I can demonstrate, we got into his office. I'm seated on the other side of the table and he's sitting here. He pulled up the statement and he didn't give it to me to read. He was holding it like closest to him. I had to bend over and read. I think he thought when I see Section 20, because it had a heading, Section 27 referral. I think the names of the person, Fadel Adams. When a person is holding a document like this for you to, but I read it. I read and I could see as I'm reading through that this affidavit is similar to the other affidavit of Mr. Adams, which is there was nothing that stood out for me in that affidavit. That
did he page it as you were looking at it?
Yes, we paged it through. I paged it. I even went to
who paged it, him or you?
I think I did. I think I was paging, even though I was still. Then I paged it through.
I thought you were saying he was holding it.
Yes, he was. He was. It's like holding it. Sort of. I can't take it, but I could page through and read. And I even saw at the last page where the deponent had signed and the commissioner of oath had signed. I could see one of them signed it in Cape Town. I think it was the deponent. But then it had a stamp, IDEX stamp of Pretoria. I can't remember who commissioned it, but I could see it was commissioned. And that is what, when I left that office, I said to Advocate Latrayo, I finally saw this elusive Section 27. I've read it, but there's nothing, I thought when this report or this affidavit is not given to, at least to me, because I was asking, there's things in there that people didn't want me to see. But when I read it, I thought, it's just the same as the statement of the complaint. There's nothing to me really.
So if he let you page the document, how is it that you say he wanted you to see its existence but not the contents? Because he could only have allowed you to page through the document if he had no problem with you seeing and reading its contents. So I don't quite get what you are saying.
Yeah. I got a sense that he was rushing me. He thought I wanted to, because I've been asking about the 27. He thought I'll just look at, there, it exists, and then leave. But then I wanted to read the contents of this and see what this affidavit was about.
I may be belaboring the point, but if you go to page 19, you even say on perusing it.
Yes.
Lawyers usually use peruse when they mean that they read a document thoroughly. And you referred to perusing and yet to suggest that you were almost not given an opportunity to read the document.
No, Chair, I read the document. I read it up to the last page because I wanted to see what was in this affidavit and that I've been asking for since August, and no one is giving it to me. But when I finished reading it, I couldn't understand why this thing was being hidden away from me, at least, or from the team, because it was just a normal statement by Mr. Fadel Adams, which was very similar to the one which was in the docket, where he's saying he got the documents underneath the door, and making complaints about a lot of issues that were happening in the intelligence office.
All right, I interrupted you when you were about to read right at the foot of the page, the last line. He retained the document in his hand.
Yes, the last line of that page, he retained,
page 18.
Yes, he retained the document in his hand, and I was not given a copy. The document comprised only of some 2 or 3 pages. It could be more. I don't remember because it's almost a year ago, and appeared to be a repetition of the complainant's statement containing nothing of substance. On perusing it, I observed what appeared to me to be an inconsistency in the commissioning of the document, in that the place at which it appeared to have been signed did not accord with the place at which it appears to have been commissioned. Like I said earlier, the deponent appeared to have signed the statement in Cape Town, but then there was a Pretoria stamp of IDEC, and then the commissioner of O2 would have signed there. And then I raised my concern with Advocate Latwaro immediately afterwards. I told her that she was going to have a problem with the Section 27 referral, because at the time I was under the impression that it was signed by the deponent at one place and commissioned by the Commissioner of Oath in another place, based on the stamp.
Is Mr. Perumal your junior at IDEC?
No, he's not. In terms of the structure,
yeah.
He comes after us as deputies.
So you are the DDPP assigned to the case, and you know that the Section 27 is missing. You know that the prosecutor assigned to the case, Ms. Latwaro, has not seen the Section 27. For the first time, Mr. Perumal says to you, it exists, here it is. And you do not insist on getting a copy of it so that you can discuss it with Ms. Latwaro, so that she is empowered when she continues with the prosecution of the case. I just don't get that. I mean, what were you scared of? Was there a reason why you didn't tell him that, listen, I want that document, give it to me now?
Commissioner Kubano, I did not think of making a copy because when I read the statement, there was nothing substantial for me. It was just like the other statements I've seen. So I thought at the time, why were they dilly-dallying from giving me this? Because there's nothing really in this. But we have a very good relationship with Mr. Perumal. I've worked with him many years ago in Kimberley. We did a case together there. So for me and him, he calls me brother. I call him Tony. So I was not scared of him. If I wanted a copy, I would have told him, Tony, please make me a copy of that. You know.
And give Advocate Latwaro a copy, because we are at discovery stage. The accused are asking for the docket. They are entitled to this document. It should be available. You were formulating draft charge sheets or amended charge sheets, and you were at a stage where you knew that the accused would be asking for discovery. You were at a stage where you are raising a concern with Advocate Hlacha. You're saying she's going to have a problem with the Section 27 referral. Why do you not insist that it be made available to her if you know that she must look at it because there are serious issues with it?
Because, commissioners, as I said earlier, there was a meeting where the ID called me and the two prosecutors, and I was told to back off from demanding this Section 27. The ID says, I've seen it. Are you not believing my investigators? So I was not going to ask for a code of that because I got clear instructions. Stay away from this, just do your job and leave the...
So you were scared of the ID. That's why you did not insist that it be made available to the prosecutor.
If one, I cannot dispute that. I didn't want to upset her. She was clear. I have seen the 27. I'm satisfied that it exists. Leave this matter alone. I hear that you've been asking a lot about it. Leave this thing off. So when Mr. Perumal showed it to me that we were coming from a meeting, and I did not even demand a copy because I knew I don't have to deal with this document. But at least I've seen it. And again, remember, I was no longer part of the case. In fact, by then, this is now in October. I've since being recused in 16 September. So, but I related the message to Joy. And the other thing is, we were told now, when I was still part of the case, when we're getting a request for further particulars, an email which I have to provide to counsel. One of the, I think that's the attorney for accused number 2, they wanted a copy of this. They said, how did you get this referral? Was it by 28, 27? We want a copy of it as part of the request for further particulars. But we were told the 27 shouldn't be disclosed. The ID said it's an internal document. It shouldn't be disclosed to the defense. And I think that is what we said to them, even in our answer, response to request for further particulars. That we can't give it to you. It's an internal document based on what we've been told. But if you look at it, there was no reason really to hide this document. It was just the same as the other statements.
Can I take you to the affidavit we have on record? If you can just have a look at, it's file 2, page 512. If you can just look through that one to confirm if that's the affidavit you saw.
Yeah, can you repeat that, please, Counsel?
If you can just look through this affidavit just to confirm if this is the one that you saw.
In most parts, yes, it appears. I'm looking for. No, it's not.
The only marker
The one that I
see-
had, the one that I saw,
Okay.
like I said, on the last page, the deponent had signed it. It was clear he had signed it in Cape Town, and the commissioner of oath had signed, but there was an IDEC stamp next to it, which was a Pretoria stamp, which is what I couldn't understand. Where was this affidavit commissioned? So the one I'm looking at now seems to have been commissioned in Cape Town. by one-
Maybe to assist you.
Sure, Solomons.
Maybe to assist you, I was going to suggest that you're making a mistake. It sounds like, because the one you are referring to which is signed in Cape Town and deposed in Pretoria. That's an A1 statement.
Yes.
It's not a 27 referral.
That is the one that was shown to me.
Okay.
It is dated, I think, the 6th of January,
Yes.
2025.
That's the
So-
Pretoria.
The Pretoria
one.
Cape Town one.
Indeed, Commissioner. That is what was shown to me. It is not this one. And even though it's almost a year ago, the one that I read, I don't remember. It's paragraph 5, which talks of Minister Mokwele. There was no reference to that in the affidavit that I read. There was no, I don't think there was reference to that in the affidavit that I read.
Please go
Otherwise-
to file 3, page 683.
In that case, and whilst you are looking, aren't you mistaken when you say that the affidavit that you saw, which had Cape Town and Pretoria, had Section 27 on it? Because on what we have been shown, the affidavit that had Cape Town and Pretoria is dated 6 January 2025, and I think between the tram lines it just says affidavit with no reference to Section 27. Are you perhaps not
I
mistaken?
probably make a mistake where I'm saying the heading was Section 27, but it had the names of Fidel Adams, and I'm looking at the one on file 3 now. It appears to be the one that I was shown. That is why even in my affidavit I'm saying it was about 2 or 3 pages, and it had this IDEX stamp on.
Go to 684, that Pretoria Cape Town anomaly.
Page 684.
Yeah.
684.
Is that what you saw just
This is
below
what I
Mr.
saw,
Adams' name?
Commissioner Kumar. This is what I saw on the day.
Do you see it says dated and signed to at Pretoria on 6 January 2025? And then it says in my presence in Cape Town.
Exactly.
Is this what you were shown?
That this is the one that I saw that the Perumal showed me.
But then this is not the Section 27 affidavit that started the whole.
Yeah. Then he showed me. Yeah, this is what I was shown. And that is why I'm saying after reading what was shown to me, I did not make anything of it because it was not saying much. It was like a 2-3 page statement which really didn't say much, and I was amazed why has it not been shown to me all along? Because it's not containing, sensitive information that I was not supposed to see or anything. If they've given me this all along, I would have stopped asking for it.
If Mr. Perumal showed you this document and said to you it's a Section 27 referral, he misled you because that this is not the referral. This is a statement that was taken and marked A1 by him.
He would have misled me, Commissioner. That is what I'm saying. After reading what he showed me, it was like I was reading one of the affidavits of Mr. Adams, which I saw in the document. It was similar. So when one says, "Oh, here's that 27 you've been looking for," I hear you've been asking questions about this. So that maybe I should stop asking questions.
Yeah, I guess the going back to the question that Commissioner Kumalo asked, that you are the DDPP at this point, because at paragraph 63 and 64, you do say that it's after the meeting of the 1st of September, and some days later, following a meeting, you went to Perumal and said he had the Section 27 and he told you, and he showed it to you. So at this point, it seems like you're still involved with the matter. Because remember, at 63, you say it's on the 1st of September that the ID said to you, why are you asking about the Section 27? And then in 64, you say some days later, I went and I spoke to Perumal. So it suggests you were still involved in the matter, which then the question remains that If at that point you're still involved with the matter, because you're not giving us a date, you just say a few days later,
Yes.
unless you are exact about when you were accused, and then we are able to see that, okay, in September he was not longer involved with the matter. The question remains that as the DDPP, Mr. Perumal is not your superior. You are responsible for this matter. You're going to be making discovery to the accused. You need to prepare how it is that he trumps your request to have the document, because there's a reason you want this document. At the very least, it is so that you can make full disclosure to the accused, but for your prep. So how is it, and why does he have the final say when you're now with him? Forget that this is not the 27 that he misled you. Let's assume it was the 27. How do you land at where he makes a final decision effectively that now you're not getting this copy that I have? And why is that okay with you, who is senior to him and in a different function?
Yeah.
Why does it end there?
The only thing I can think of, Commissioner Balo, is that he had the support of the ID. He probably knows that the ID had told me on the first that I must stop asking about questions about this 27 and just continue to do my work. So that is why maybe he's also just showing it to me and not giving me a copy, because he knows that I've been told not to ask questions about it. And because I was following on what the ID would have said to me, that is why maybe I also did not insist on getting a copy. The other thing the ID said to us, these 27s are not given to the defense. So when we were going to answer the request of further particulars, we're not going to give copies to the defense. The instructions were these are internal documents and they shouldn't be disclosed.
But you knew she's wrong. It's not an internal document. It's a Mr. Fadil Adams document. So it comes from outside into the IDEC. It is what gets a docket opened in the first place, because without it, you would not have opened a docket. So I expect that the prosecutors would know that, but she can't be right. That it's an internal document. She can't be right that it's not to be disclosed. Is that a fair proposition to make? That the prosecutors must know she's wrong.
Yes, but again, Commissioner Baloyi, I couldn't say to my boss, you are wrong. I'm going to disclose it anyway against your instruction.
You may for your reasons that you give not contradict her, but the fact is, as a matter of process, it means there's no full disclosure.
There isn't.
To the accused, and that has consequences. It could be any other document. From where I'm sitting, that if on something like this you have a head who says, no, we're not disclosing that, it's an internal document, and everybody around her knows that what she's saying is not correct, but they comply, then it doesn't give faith that on any other matter, if she says that we are not disclosing, that her prosecutors will not say, well, if I must lose my job, I'm going to lose my job, but my integrity and my responsibility to my profession and to the court is that I make disclosure. That has a sense of discomfort about it. And either she was particularly powerful, and so nobody dared to say, but that's breaking the law when we do that. Or she works with prosecutors who are okay to look the other way, which is deeply problematic. And I don't know which is worse. But that's the sense that, that a sense of discomfort
I understand that.
that all of this creates.
I understand that, commissioners. Yeah, it's difficult to be in a position where I was at the time. I couldn't. I didn't have the guts to say to my boss, "You are wrong. I'm going to disclose this, whether you approve it or not." I know there's going to be consequences. Can be disciplined. That can be charged, and so on. Especially that we have signed non-disclosure forms. So it was going to be, you disclose a document which we have told is an internal document, and therefore you're facing up to 15 years imprisonment for this. So it was that. But if you didn't say to me, don't disclose it, it was going to be part of the disclosure. But we were told categorically clear, it's an internal document, you don't disclose it. And it is on those bases that I wouldn't have gone against it.
All right, I've heard your answer. Thank you.
Another process-related issue. A witness, I think it was Ms. Ramsamy, said that the Section 27 referral affidavit becomes the A1 statement, but that you may supplement it should that become necessary. Is that your understanding as well?
Chair, that is my understanding, because the Section 27, when it's sent by a complainant, that forms the basis. That's the first document that we receive that says I've seen or I suspect that such and such an offense has been committed. Maybe provide evidence to that, documents, invoices, and that's the first document that we have when we're opening an inquiry file, as we building up our case and investigating. Now, if it's not sufficient, we'll go back and obtain further statements. But now, when it comes to the disclosure stage, why should we then give to the defense all of these other documents, but not this one, which was the basis of why we started this investigation? I would understand if it contains sensitive information on informers and how government operates, like the court says when we're doing normal disclosure. But if it's a statement like this one of Mr. Adams, I don't understand why it had to be kept away from the defense, because it is a complainant statement. It forms part of basically the inquiry file, and later when a docket is open, it should form part of the docket and be disclosed, like all the other documents. And
also not just as a matter of process, it actually makes practical sense that it should be out there for all those involved in the investigation to see. Why? Because it is the source document for the investigation. Why it should be kept by whoever secretly simply doesn't make sense whatsoever.
Indeed, it doesn't. It didn't make sense even at the time, and I think maybe going forward, this is what. And I know some of the colleagues are listening to this. These are debates we must have in the office. If we have to beef up our manual, we have to do that to be clear on these issues. And if at the end of this commission, if according to your powers, commissioners, you're going to make recommendations, maybe that will also come up in your recommendations on this 27. But it forms part of the inquiry file. It forms part of the docket, and it must be disclosed.
Thank you.
Just to complete the picture, the Section 27 that you were shown, the one that we find in File 2, we know that on the 9th of October 2025, it did not exist, because in File 10 on page 402, you don't need to go there. There was a scramble at IDEC offices because people were looking for the Section 27. And Ms. Ramsamy was asked about it, and Mr. Perumal inquired about it. Nobody knew where it was. And they thought she had it, she had kept it since December the previous year. Even when Advocate Johnson went to the ad hoc committee in October or November last year, she could not produce it. she raised various issues, but the simple point is on the 9th of October 2025, Mr. Perumal did not know where the Section 27 was, and everybody in the office was looking for it. And they actually thought it is missing or it has been destroyed.
Yeah.
Let me add to what
Yes.
there's in fact now controversy about what is the Section 27 affidavit that started this investigation. You have followed that evidence, so more the reason why you would expect, and I hope for my part that those who are listening, your colleagues, they understand from this evidence that we've set through why it's important for the lead prosecutor to have sight of that Section 27.
That's true. I agree, commissioners. I agree. It is very important. And I do not know about the other issue where the document was searched for because the ID had to report it ad hoc. But what I can say, during that period of October 2025, I was also looking for it. And as I've shown through the email that I've sent to Mr. Sok on the 31st of October, I was still asking questions about the existence of this document. So when Perumal showed me the document, it must be after 31 October, because by 31 October, as it appears on PS10, my email to, and it's not PS10 in one, PS10.1, my email to Mr. Sisoko on the 31 of October, I'm asking, do we have a Section 27 referral in this matter? And if so, where do we get a copy of it? And yeah.
Maybe what's confusing about your statement is that paragraph 63, you talk about the 1st of September, and then you say some days after the management meeting. And that seems like you saying second week of September. But in fact, when you go to your annexure 10.1, it's the 31st of October when you are asking if we have the 27 referral.
Yeah.
So maybe your statement is incorrect where you say some days after the management meeting, because it looks like it's a month or two after.
It's actually about 2 months after.
2 months after.
Yes.
So maybe we should correct your statement, paragraph 64, to say or know about the 31st of October 2025.
I'll be glad if that is corrected, Commissioner, so that I don't create a confusion. But obviously, if one looks at the date sequence, it should have been at least on the 31st of October or thereafter.
Or know about.
Yes, or not about. So it couldn't have been, yes. So if paragraph 64, the first line reflects that, to say, my meeting with Chief Perumal happened on or about 31 October, or at least after 31 October.
Advocate Serunye, then you were at paragraph 65.
Yes. At 65, for the reasons already given, it was my view that the arrests were premature and that the matter had been brought to court before the investigation was complete. The verification of Ms. Mokwele's qualifications, the analysis of financial and communication records, and the assessment of the appointment process were all matters that ought to have preceded and not followed the arrests, I'm saying. I then get to the Lushaba matter at paragraph 66.
My apologies, Advocate Serunye. Chair, may I ask for a short adjournment? I've been sent a note to request a short comfort break.
We'll hear from you when we're ready. Let's adjourn.